Dixie where the eagles fly, land of the brave where the bullets don't lie. We fought for our freedom with guns by our side. Red, white, and blue, our southern pride. Raise the flag high, let freedom ring from the rolling mountains to the flatlands. We sing, no one can take our rights. Our Second Amendment will defend our land. With every bullet we stand. We were born in the USA, land of the free. With guns in our hands, we'll forever be. Southern blood runs deep through our veins. We'll stand tall for America till the end of our days.
Good evening, all. Welcome in. I'm Sully, and welcome to the Gun Club. We're going to have an interesting one tonight. It's kind of a weird one. It's going to be a compilation of a couple of previous videos I've done because we've got a policy situation that has reared its head. And if you don't look at the specifics of this and just look at the general concepts of it and the general 30,000-foot view, it says so much. It really does, because it shows us a lot about not only the ATF, it shows a lot about the GOA, Gun Owners of America. It shows a little bit about the NRA, unfortunately, and we're going to talk about that. In order to sort of get to this, we've got a lot of content and a lot of stuff I'm going to be showing. There's a lot of show and tell on this one. Sort of bear with me as I work through this because I'm flying solo behind the scenes here. And it is going to be a very, very interesting event. Now, for some of you, this may mean nothing as far as the specific issues that are addressed. However, when you look at the, again, 30,000-foot view, you'll see, wait a minute, what are they doing? How stupid are these people? Well, you're going to find out here in a minute. And after it, I think you may even sit there and want to laugh. And I know when I was reading this and putting it together, I was talking to a friend of mine and explaining some of the stuff that was going on. He's like, are they nuts? And I was like, I don't know if they're nuts or where they're at, but it definitely shows some problems in the system. And I am hoping that, with the resignation of Stephen Dittelbach from the ATF, I'm hoping with, a president coming in who's a little bit more pro-2A. I won't say he's great, but a little bit more pro-2A. Maybe we can make some tremendous improvements in this, because stupid Stephen, he's not a very smart person, and apparently some of the people who work for him, he hired a lot of not too smart people to work with him. I see Mary's wandered into the chat. Good evening, my dear. Hope you're having a wonderful day. Yeah, this one dates back to one of the earliest streams I did when we started talking about pistol braces and what a pistol brace is. Now, for those of y'all who weren't here then, we're going to do a quick catch-up and sort of try to bring everyone up to speed. So, it is now 2025. Way back in 2022, 2012, SB Tactical developed a concept of what was called a pistol brace. It was a device designed to allow individuals who either had very limited hand and arm strength, or may have lost an arm or lost the use of one arm, to be able to more easily use larger pistols. SB Tactical, the company who designed the concept, submitted the information about the design to the ATF, and the ATF approved it. And that's a big one to know. In 2012, the ATF said, yeah, it's cool. You can make these things. You can sell these things. We think they're cool. Evening, Scott. Glad to see you here wandering into the chat. Yeah, this is going to be sort of a flashback of some of our crazy stuff. Aloha and hola to you, senor. You know, hope you're having a very wonderful day. So, SB Tactical, totally approved by the ATF. Can you rely on that? I mean, the Fed said it's okie dokie. They actually submitted, this design of the pistol brace concept. This is what it was, and it has basically the Velcro strap going around it there to strap it to the user's hand or wrist. And again, there's the submission, there's the design. That is what they sent. Now, there's a big difference between a pistol brace and a rifle stock. If you look on the left, those are pistol braces. You can see where it's got a place to put your wrist through and a Velcro strap to hold in place. On the right, you see it's a rifle stock. It's solid. It's designed to be nestled up into your shoulder lovingly with a good cheek weld as you fire a rifle. The question that SB Tactical raised was, is that thing on the left considered a stock? If it would be, that would make the firearm a rifle. On the other side of the coin, the one on the right would be a stock. Yes. So the one on the left would be considered a pistol. The one on the right is considered a rifle. The frame of it makes no difference. The trigger action, no difference. They're both semi-automatic firearms. So, yeah, I agree. Matt from CRS would say, probably not. Now, as we go through and we're looking at this, the ATF, again, approved this design, said it was okie dokie, Smokey. And that's, one of my braces right there. Now, the big difference between a pistol and a rifle is a pistol can have any length barrel. They've got the little pocket rockets. You've got Derringers. You've got little snubby, 1.5, 2-inch barrels. A rifle could be any length, but if it's under 16-inch barrel, it's considered a short-barreled rifle. It's considered much, much worse. They actually did this, and when they wrote the NFA way back when, they said it was because a shorter rifle would be more concealable. So we're going to go with a little ATF logic here. And again, that's right, an oxymoron to begin with. If a rifle has a barrel of 15 inches, it's considered concealable, but at 16 inches, it's not. Somehow, magically, that 1 inch matters. Yeah, apparently ATF logic. Size matters to them a lot. Anyway, we're dealing with this, and so we're having this wonderful situation of if you want to have a barrel less than 16 inches, you cannot have a stock on it. You can have a brace. You can have just a regular buffer tube cover. You cannot have a stock. It would be a rifle, making it an SBR, which is much more deadly. Now, when you look at the big scope of things, we'll talk about ballistics for half a second here. The shorter barrel has less muzzle velocity, thus less power. So an 8-inch barrel has less power with a 223 or 5.56 round than a 16-inch barrel. So they're less powerful, but they're readily concealable. Now, if you can readily conceal a firearm that's got an 8-inch barrel, full frame with a buffer tube on it, it never made sense. It never passed the logic test, but it was the ATF test. Just an interesting footnote here. When they originally wrote the law, they said 18 inches. Then they cut it down to 16 after the government accidentally sold a bunch of 16-inch long barrels and realized, oops, we were selling illegal firearms. So they changed the law to make what they did legal. Yeah, folks, you can't make this stuff up. So that's our pistol brace. That's what it does. That's what it's designed for. When we look at this, May 2013, SB Tactical, they had received approval the year before. They, Sig Sauer, Century Arms, began marketing these. Well, now, while this design is available for different firearms, one of the most commons is the AR pistol platform. The ability of these devices to become more controllable, more popular, and a lot of people had them. I have a few of them. Why? Well, Because if I want something more controllable, one-handable, hey, it makes it easier to use. Fine. Well, it became obvious that people were using these to shoulder the firearm. Now, if you look at the surface area, I won't say you can't shoulder it, but honestly, you end up with something that's like this. You're not really moving the firearm. It's doable, but not functionally very good. So it led to a question that if the firearm was used from the shoulder, would that still be a pistol, or would it now make it an SBR, depending on how you hold it? Well, I mean, how you hold it, changing the classification. So this either is or is not a federal felony, depending on how I hold it. Yeah, government logic, folks. In March of 24, the ATF came out and stated they're not going to cause the firearm to be reclassified just because someone's using it in a different way. Now, think of some of these shorter firearms. They're actually a lot easier when you're training new shooters, when you're teaching someone who's new or smaller. I mean, I'm 6'2", 6'1.5". Again, Mel says inches matter here. More power to you, darling. Look at it this way, though. If you've got someone who is smaller in frame, smaller in stature, doesn't have the wingspan I have, and they want something a little bit shorter, a little bit smaller, more controllable, maybe easier to defend their home with, easier to move room to room within their home, makes sense to me. Now, any of these firearms would be smaller than, say, a standard Glock pistol with a 15 or 18 round mag in it. So it's not, oh, it makes it small and concealable. If you want something small and concealable, you go with a handgun, not a AR with a pistol brace. Just saying. Now, in 2015, the ATF comes out and says, we're going to reverse our previous decision. Everybody who has those and bought those, if the braces are fired from the shoulder, we're now going to reclassify the gun. Meaning, if the ATF walked out to the range and happened to see you shouldering a brace, well, that's a federal felony. Really? 10 years in federal pound them in the ass prison because you shouldered a rifle or you shouldered a pistol? It made no sense. This got a huge legal battle going between SIG and SB Tactical saying you approved this in writing. This was good. There was nothing here. In 2017, they said, that thing we did in 15 doesn't make sense. We're going to go back to our 14 position, which was consistent with our 2012 position. And remember, these are the feds. These are the rule-making. I won't say lawmaking because ATF does not write law, and that's a big problem they have. They think they do sometimes. But they're writing federal regulations that can cause you, me, or any other law-abiding gun owner to have something totally legal in our safe one day and a federal felony in our safe the next day with no change on anything we've done. And that's not fair. It's not right. You can't go out to a road that's got a 45-mile-an-hour speed limit on it today. I drive home at 45. You can't change the speed limit the next day to be 30 miles an hour and write me a ticket for 15 over. That's crap. And that is what they have done with these. Oh, yeah, we said it was fine. Millions of them are sold. Now they're not fine. And we demand everyone turn in their property. Well, turn it in and we'll kick down your door, shoot your dog, and, order your 17-year-old daughter out in 20-degree weather in a tank top and panties because, we're the ATF, right? The ATF has overreached with this so badly for so long, and we thought it was done. Well, this was the honey badger. This resulted in a letter in 2020 to cease and desist. That's now considered an SBR. But wait a minute. It wasn't in 2017 when it was designed. Ugh. Are they going to make up their mind? Again, tell me what the law is and we'll obey it to the best of our ability or we'll fight to change it. But don't take something that's totally legal today and put me in jail for it next month. Well, after the uproar from the gun community, Congress, the proposed regulations were then withdrawn 12/23 of 2020. Now, you wonder why I'm going through this historical, analogous historical trip here. Well, folks, it keeps going. In June of 21, the ATF again aimed to redefine rifles in such a way as to exclude the braced ARs and call them short-barreled rifles. It was based on a point system that they said owners could use through a point calculation system. It had a really cool chart and everything else. And, you could grade your guns, and if you graded it correctly, you were legal. If you completed their chart and their calculations, or you missed something or didn't consider something the way they considered it, well, you go to jail for 10 years. You know, for a side here, there is something called the rule of lenity. And the rule of lenity basically states generally all laws in the country, if a law can be interpreted two different ways or is not clearly legit or not clearly specified, and there's a gray area, it must be determined or read in the way that is most favorable to the defendant. I'll backtrack that. The rule of lenity, and this is one I know Mel may be familiar with this from her work in the law office. Some of y'all may have heard this. If a rule can be read two different ways or determined or two different possibilities, the rule of lenity says if something is vague, it should be read in the light most favorable to the defendant. Meaning, if the defendant could have read what he was doing was legal, we can't read the law a different way and say, oh, well, we don't think it was read that way. No, rules should be clear and specified. Again, the speed limit sign, it should be 45 miles an hour. That's the speed limit. You can't, have it as, something that's very, very vague. Speed limit, not too fast. That's a subjective as opposed to an objective number. I agree. Mr. Scott Awesome, Kim Potter's judge in that case, she failed epically, in my opinion, but, we can definitely throw that one out there. Yeah. And yes, I understand that. Okay. I'm sorry, Mary. We'll kick this out of there. Is that better? The ATF creates this form to grade your guns. Now, the form had all the clarity of an IRS tax table on it. So, yeah. So, as we go through, here was the form. And you get to figure out, you do the calculations and figure out. And again, looking at it, does it have a target grip on it? Does it have target sights? Can they drift or can they click? Can they be adjusted? Does it have a target hammer or trigger? What caliber is it? Looking at, some of it, it was ridiculous. And that factoring criteria, when they put that out, got a lot of complaints. Because again, depending on where you qualify your gun, depends whether it's legal or not. Well, in January 2023, they finalized the latest version of the regulations and were scheduled to begin enforcement on May 31 of 2023. Their ruling will effectively reclassify braces as a stock. Very simple. Thus, these pistols, anything with less than a 16-inch barrel on it, now became a short-barreled rifle. So it suddenly became an NFA item. Now, big to note here, as an NFA item, we'll talk about what an NFA item is. NFA items are perfectly, totally legal. However, they are regulated. You can own a short barrel rifle. I can own a short barrel rifle. You just have to go through a special permitting process and pay a special $200 tax fee for owning it. Totally legal. Anyone can get one. You just got to pay more for it. So we can have them on the streets. People can own them. But you just go through a different background check and pay more money for it. Okay? Because it has a 14-inch barrel, not a 16-inch barrel. Again, like Mel said, apparently those 2 inches, that must be a big deal to people who work at the ATF. Just saying. So they've done through this, and they've pretty much, made in what I would consider a train wreck of a series of mistakes, because we have, all of a sudden, this became NFA items. So we had to all pay a tax stamp. Well, multiple lawsuits were filed, and they were trying to, number one, get an injunction to delay the enforcement while the cases are pending. You can't tell me that, oh, by the way, when you wake up June 1st, that gun that you had that was legal last month is now illegal, and you have to take those braces off or destroy them or turn them into the ATF. And again, when you turn them in, there was no compensation. Turn your property into the ATF effective immediately, or, like we said, they may come knocking at your door. Do they have a list of people who bought these? Who knows? We have to wonder. Given what happened with, Dexter up in New York, you can always wonder. This was ridiculous. The lawsuits flew every which way but loose. So you had your choices. Reconfigure it in such a way as to make it a rifle. Put a longer barrel on it. Okay. Complete all the requirements to register it as an SBR, and they did say during that time they were going to give you a break on the taxes. Destroy or surrender it, or, well, you could roll the dice. You could keep your gun that was legal last month, and in June you were a federal felon. Yeah, it got great. Well, some of the NFA regs, you had to get additional fingerprints, you had to get approval from the ATF to travel across state lines, had to pay that $200 tax stamp. You must control it at all times, meaning if you're at the range and your buddy wants to borrow it, that could be an issue. And there were even some states that did not allow people to possess NFA items. So if you lived in one of those states, you couldn't even do all the $200 and keep your own firearm. They made a mess. And everyone kind of figured it was a mess. And so what happened? Well, lo and behold, we all joke about the fact that sometimes, calmer heads prevail, and they actually made a little bit more sense out of some things. Fortunately, we had some decent judges, and one of them we're going to talk about is Judge Reed O'Connor. I'll pull this up here. After a series, and I mean a series of lawsuits, arguments back and forth, depositions, briefs, and all sorts of legal stuff, which, I know Mel would have enjoyed it, but it got a little bit stupid for a while. We came up with this. And here is where it all sort of finished out in June of 2024 after court injunctions and everything else. And I'll blow this up a little bit to make it much nicer to read and see. Because the defendants, i.e., the ATF, fail to show that this is a rare case in which the court should deviate from the default rule, court vacates the final rule on the grounds that the defendants, the ATF, violated the administrative procedures requirements promulgating this rule. Courts presume the federal government will comply with its ruling. The plaintiffs, GOA, NFA, GOA, NAGR, FPC, several things. This was the Mock v. Garland case. And in this one, the court granted the plaintiff's motion for summary judgment on the grounds that the rule violated the Administrative Procedures Act requirement. They said it was arbitrary and capricious. Their words. Very nicely said, Judge O'Connor. Definitely appreciate it. They denied the motion for summary judgment, denied the plaintiff's request for permanent injunction, so it basically vacated the rule. That right there vacates the final rule. They took the new rule that the ATF was trying to put out there, and after arguments and arguments and arguments, and you can go back and look at my pistol brace videos, because this was like in every couple of weeks, some court was doing something with something, and there was an injunction or something. They vacated it. Now, this has been a train wreck that's been going on since, 2020, 2021. It was very much settled by Judge Reed O'Connor here in 2024. They took their final rule and said, no, done, it's vacated. We thought it was over. Anyone in the 2A space, the 2A community, who relied on, here, this is a federal court judge telling the ATF, I'm vacating your shit. Your rule is gone. We can't have rules like this. This is unfair. Again, it doesn't meet the rule of lenity. It doesn't meet several other things. And again, a federal judge threw the ATF's ruling in the circular file where it so desperately belonged. But does that federal court really mean anything to the ATF? What do you think? Are they going to listen to a federal court? Are they going to follow along with what the federal court says? Because you know what? Let's watch some overreach. And this is where we come to today. Congratulations, we're done with the history lesson. It's now late June 24, and we're good. Or are we? Well, a gentleman, I'm assuming it's a gentleman, I believe they've actually gotten his name out. I'm not going to cite his name on here. He went out and bought a pistol, and he asked the ATF a question because he was getting a lot of conflicting information. Now, alrighty, good night, Scott. Hope you have a wonderful shift tomorrow. Good luck. Coworker went ice fishing and said I would cover his shift. Yeah, if you would catch it on replay, you'll definitely enjoy this one. I'm at full rant for this because it's funny and there's definitely a real nice hook at the end I've got saved up for us. So, the ATF, after getting slapped down with this one, getting slapped down in the Michael Cargill v. Garland case, that was the bump stock case, where Michael Cargill got the bump stock ban taken away because a bump stock is not a machine gun is not a bump stock. Yeah. And he's got another case in here too. This gentleman, trying to be a decent law-abiding citizen, send a letter to the ATF. Yeah, because you should be able to ask federal regulators when you're getting conflicting things on federal regulation, give me the truth. He sends this letter in. I recently purchased a CZ Scorpion mini pistol, and I'm considering installing a pistol brace. However, I've encountered conflicting information regarding whether this modification would require the firearm to be registered as an SPR, meaning $200 tax stamp, all those extra requirements, extra background stuff. Could you provide clarification on the applicable regulations? Now, let's backtrack for a second. While asking them should be a logical thing to do. If you want to know something about motor carrier law or federal transportation or truck driving law, ask a DOT cop. If you want to know about the city ordinance, you should be able to ask a city cop. If you want to know something about accident investigation, ask a highway cop or a reconstruction specialist. It would make sense. You know, if you want to know something about environment, ask an EPA cop. Great. So in a normal, sensible society where the people at the ATF, whose salaries, benefits, and everything are paid for by tax-paying citizens, this gentleman trying to be a law-abiding citizen should be able to, they should help him comply and be legit and a resource to him. Because remember, his taxes, your taxes, and my taxes pay these idiots salaries. So in theory, they work for us. They're not the enemy. They should not be the enemy. In theory, okay? Folks, I know I'm going to get hell for that line, but I'm saying in a normal functional society. Yeah, in a normal functional society. Yeah. Now, you have to realize they have these individuals at ATF who are considered, somewhat experts. And these technical experts, in theory, should be a resource, not only for, let's say, people looking at buying firearms, people dealing with different things. Normal world would say these people should help us and help the 2A community be legit. But unfortunately, I'll show you what we have to a point with some of the ATF folks. This is our ATF at work. This was when they were trying to explain how bad ghost guns were. And yes, one of the people featured here is soon to be gone Stephen Diedelbach, which, stupid Stephen. He's not a very smart man. He's smart. He's getting out with his pension before I get in office because I'm coming in on Monday and I'm going to do something really bad to him. But that's okay. He quit today. You know, we can laugh about the ATF going down in just epic stupidity because here we go. This was the ATF in a big Face the Nation presentation where they're talking about ghost guns.
So that's the frame.
Now, the gentleman to the far left with the dark hair is Stephen Bach. The gentleman on the right is one of the experts from the Technical Bureau, and he is trying to disassemble, i.e. slide the slide off of the frame on a standard Glock pistol. Field breakdown should take you no more than like 15 to 30 seconds if you're familiar with your weapon. Also note, a lot of the ATF agents carry Glocks, so this should be, if he's been around any length of time, he's carried a Glock or shot a Glock at some time, this should be a gun that he is intimately familiar with. He should know his way around that Glock as well as he knows his way around his wife's. Anyway. Starting to feel sorry for his wife. He's going to try to take this one apart now. I can do it.
He's going to make a new gun for
Got
it.
that apart.
So basically what they do is they make this part here.
This is like plastic.
So this is the plastic piece. With about 20 minutes of work, they could make it into a working firearm, and then they could buy the aftermarket parts and simply attach that on.
And to buy those parts, is there any serial number and tracing of?
Now, you don't have to,
pieces?
if you're selling firearms parts alone,
Mhm.
right? Then it's not a frame or receiver.
Parts are not regulated.
And
by
they're not
anything.
regulated. Under the law, we're not allowed to do that.
You
Right.
would like to do that?
That's up to Congress to determine. But I mean, what we did is we tried to work with the law that Congress gave us and take the receiver, the
Mhm.
frame. This is a frame. A frame is on a pistol, receiver's on a.
Now, you'll note, Baldy there just handed the gun to someone off camera because he has tried to manipulate and pop it open and break it open. He can't. Folks, this is like, what the, these are the experts. Now, this again was a ghost gun argument, but the whole thing is, here you have an expert on camera trying to field strip a Glock who can't.
Right.
Gun. We take the frame and say, hey, Congress said we can regulate the frame,
Mm-hmm.
right? And so people that are.
And keep noting, he keeps saying, Congress said, Congress said, Congress said. In this, he's admitting it's a congressional issue. It's not an ATF issue. Congress writes laws. Congress is also accountable to us. The House of Reps every 2 years, the Senate every 6. If they write laws that are bad or they write laws that we disagree with, well, they get primaried, they get voted out, they end up having to find a place, waiting tables at Denny's. Mel, exactly. It really is. It's almost as bad as Tampon Timmy trying to reload a shotgun. I will say this one, and this is just my observation. Yeah, at least Tampon Timmy trying to get a load in his shotgun. Again, that may be the same quality of work he does trying to get a load in his wife. I don't know. I'm just like done with some of this stupid. I mean, this to me is the latest and greatest in the ATF proving that they are absolutely, positively incompetent. I mean, we can go through the legal and overreach in the Malinowski raid. We can go in the, Mark Chopper raid. Those train wrecks. We can go with the court spanking them on the Cargill case. The court spanking them on the Mock v. Garland case that you just saw. The ATF keeps doing dumber and dumber. And again, the man right there on the screen is the one in charge of it. Fortunately, He has resigned. So we can keep laughing at these idiots. Now, remember, Baldy handed the gun off screen to someone else. Watch this.
They're readily, convertible to being firearms like this. Like you said,
He's
20
still
minutes. This
working on
is
it in
like
the
the thing that
background.
even I could do,
Mm-hmm.
right? So made sure that this has to have a serial number on it from now on, right? So that's what we're trying to do.
And some of the argument right now, like in California.
So that is, this guy trying to manipulate this, and it was absolutely atrocious. He could not do the basics. And it was like, are you kidding me? So there's your level of competence from the ATF. So let's backtrack to our letter here. Nice, law-abiding citizen, simple letter. Hey, I've encountered this. I've got this pistol. I've encountered conflicting information. What's the rules? He gets this letter back. Now remember, the rule that is put out was enjoined, as in a federal judge said it was no good back in June. So what do we do? Well, can we still enforce that rule after the federal judge said hell no? You'd think they couldn't, but got this one from our friends over at GOA, and you'll see why here in a minute. Two, and this is the Firearms Industry Policy Bureau. Hello. Thank you for your recent inquiry to the Bureau of Alcohol, Tobacco, Firearms, and Explosives. In response to your recent email, you inquired about stabilizing braces. In your message, you stated you recently purchased a CZ Scorpion Mini Plus pistol and are considering installing a brace. You then stated you've encountered conflicting information regarding whether this modification would require the firearm to be an SBR and asked for clarification. Federal law requires a pistol with an attached stabilizing brace or stock be registered as a short-barreled rifle. Federal law requires this? Show me the law. Show me the law. There is no federal law whatsoever that requires it. There was a rule promulgated by the ATF that came out with that. That rule was thrown out by a federal judge back in June of 24. So we literally are sitting there. This is the ATF. This is the experts sending this. There is no federal law that requires this. They're saying there is. I guess, the ATF can say anything is law. There's your problem. Now, let's keep going. As you may be aware, a final rule in 2021 amended the definition of a rifle and clearly states, so federal law requires it, but you may be aware that a rule stated, it's not a law there. It's not an act or no, I don't see that. Has amended definition of a rifle, claims designed, redesigned, remade, fired from the shoulder, includes a weapon equipped with an accessory or component or other rearward attachment, a stabilizing brace that provides a surface that describes the weapon they go through. Now, it's really interesting. Current status. On November 8th of 2023, U.S. District Court in the Northern District of Texas found the final rule, the factoring criteria, violated the Administrative Procedures Act and issued an order staying the rule in its entirety. That was in November, they stayed it, and then in June 24, they vacated it completely. This was a national case that went on forever. You'd think the ATF would know what they're talking about. Again, well, we saw them try to disassemble a Glock, so yeah. The district court's order does not prohibit enforcement of the National Firearms Act or the Gun Control Act. No, but they do prohibit calling a brace or stock. They do prohibit saying this. It remains responsible for enforcement, a rifle having a barrel less than 16 inches, yada, yada, yada. Again, we trust the foregoing has been responsive. Should you have additional, please contact your local ATF office. Phone numbers can be found here. There's from Firearm Policy Bureau. And down here, this is the original email. It's just sort of a nested form. Now, this email came out, and it was made it over to our friends, and I say friends very, very lovingly because they are our friends at the GOA, the Gun Owners of America. And the GOA said, "What? You're joking, right? Who's nuts?" The GOA knows that a federal judge has told the ATF, "You can't do this." They're doing it. And this is the overreach. When you hear people talk about the deep state or the administrative state, Congress never made that law. It was a federal interpretation of a wonky law that they interpreted way over the edge, that got sued on, got thrown out in multiple courts. Finally, a district court judge said, no, it's vacated completely. That is garbage. You can't do that. They said, well, yeah, we will anyway, because we think we can. You know, without getting all sorts of political, we've got three branches of government: the executive, the legislative, and the judicial. They check and balance each other. When the executive overreaches and Judge Reed O'Connor in the judicial slaps their hand for it, they're not supposed to say, yeah, screw you, Judge, we're doing it anyway. They can't do that. So, Eric Pratt, Senior VP at GOA, and before I go any further, I want to throw this out there. When we're talking about some of these places like GOA, especially, I am a big fan of GOA. Y'all who know me know that. Why? Well, simple reason. If you were not following any of this, I follow this stuff real closely. If you're not following this, it's the men and women, the people like GOA, FPC, Firearm Policy Coalition, Second Amendment Foundation, they are following this. This guy gets this wonky email back from the ATF. Who is he to really take on the ATF and call them out? He's not. The people of the GOA step up and they jump in for it. And I'll tell you, one of my favorite ways to support the GOA is always by buying coffee. Yes, because if you buy from Blackout Coffee proudly supports the GOA, the Firearms Policy Coalition, and the Second Amendment Foundation. They've actually got coffee, special GOA blend, and it's actually pretty damn good. And you can see those are real K-Cups in my real house. Why? It's at my real coffee maker because I would support these guys because they support us. Every one of the sets of the GOA K-Cups you buy has a donation to GOA. If you buy FPC K-Cups, it donates to FPC. These organizations are willing to do battle for us. These are the people preserving our rights. These are the ones who are saying there's no compromise on the Second Amendment. The GOA Minutemen are the ones saying, what part of shall not be infringed did you not hear, Mr. Needlebach? These are largely the ones that when Stephen Needlebach goes to bed at night, make him weep a little bit and maybe suck his thumb. Or, well, something else. But anyway, they've also got all sorts of really cool flavors: butterscotch, chocolate cherry, peppermint mocha, as well as Jamaican Me Crazy, Climax. Maybe that's what Mr. Needlebach needs to drink. I don't know. But if you check out Blackout Coffee, promo code Gun Club, you get 20% off your first order. And to me, I'm going to drink my coffee. We all know that. But if I can drink my coffee and support the people fighting for our rights at the same time, I'm in, bro. I am all in 100% because, doing stuff like that, they're the ones who support us. The reason we have our 2A stuff is because of organizations like this. Here's a whole bunch of their different blends they have, and it shows, Second Amendment Foundation, 2A, 1776 Foundation, Gun Owners of America. And again, you get 20% off. So, hey, check it out. I'm more than happy to do an ad read for these guys anytime because I know off the top of my head that these guys do a lot of great work for us. And again, if I can support them by drinking more coffee, I've got a win-win on that equation. I really do. And yeah, I'll say Mel, she loves her Jamaican Me Crazy. I think she's got a bunch of flavors from there. You can tell me in the chat, Mel, what your favorite flavors are from there. Personally, I'm kind of old school. I'm an old fart. I like my coffee flavored coffee, but I'll get my GOA blend. I got a little Morning Reaper. I might have a little Brutal Awakening, which is a darker roast, but they're all damn good coffee. And yeah, I go through plenty of them around here, and they've got them in mixed, they've got them in bean, they got them in K cup or ground K cups, everything else. I love that stuff. So yeah. Now, when you see I've just preached all the glory of GOA, let's watch what GOA did with this train wreck. So, pull me off here so I don't get yelled at by Mary. Yeah. Dear Acting Chief Scheer and Chief Ryan, my name is Eric Pratt. I am the Senior VP of GOA, Gun Owners of America, and the Senior VP of the Gun Owners Foundation. GOA and GOF are nonprofit corporations dedicated to preserving and defending the Second Amendment rights of gun owners. Hurrah! GOA and GOF together have more than 2 million members and supporters nationwide, and they need to drink more coffee. As you no doubt are well aware, the federal court injunction that protects the GOA's members and their resident family members from enforcement of the final rule entitling festering criteria for stabilizing braces and the pending merits. This injunction halts enforcement of the ATF's theory that under a vague and open-ended factorial test, the vast majority of commonly owned brace pistols are in fact NFA-regulated short-barreled rifles. GOA's injunction and another court's outright vacature of the rule also halt the rule's rescission to prior brace pistol classifications, thereby preserving the pre-rule status quo where numerous ATF-approved braces could be added to pistols without incurring criminal liability. Okay, so we've got Mel in the chat here saying, Climax is good but has a strong flavor. That's what she said. Butterscotch toffee, yeah, okay. And cookie doodle. As you can tell, Mel has used our promo code, and these guys do great. And I've got lots and lots of their coffee. As you can tell, I'm well caffeinated for this one tonight, courtesy of our friends over at GOA and Blackout Coffee. So yeah, check it out. And again, promo code Gun Club save you a couple of bucks on the deal. And again, you're supporting the two-way, which is really big to me. And, not to throw any other coffee under the bus, but there's some of them that try to pretend like they're all about this, that, and the other, because they're all about rifles and this, that, and the other. When I find a coffee company that actually actively supports the GOA, which is one of my favorite groups, as you see why. Yeah. So. Reading onwards and upwards, nevertheless, on December 12th, an email signed by an ATF firearms industry program branch, one of the technical experts, was sent to a GOA member advancing a concerning interpretation of law that the federal law requires a pistol with a brace to be registered, or stabilizing brace or stock be registered as a short barrel rifle. See attached correspondence. Look, Mel, I will call people out. I don't like friendly fire incidents, but I will call people out sometimes because, some people try to play the game, but GOA, they walk the walk. And you're seeing in these emails what I mean when they walk the walk. For starters, the correspondents claim to adopt this position of a matter of statutory interpretation, thereby purporting to sidestep the injunctions in place against the rule. So we think this is the rule even regardless of what the court said. Of course, the rule is based on a flawed interpretation of the statute. Indeed, it is GOA's position that this too cute by half approach risks putting the ATF at odds with injunctions and the vacature blocking enforcement of the rule and consequentially interpretation of the statute. Yeah. What's more, FIPB's novel interpretation expressed in the December 12th email goes much farther than even the rule itself, which assured that only certain weapons with stabilizing braces would be SBRs, not all of them. To our knowledge, ATF has never taken the position advanced in this December 12th email that a brace attached to any pistol makes it an SBR. Well, they've never taken it, but they're promulgating it. I therefore write you informally in the hopes that you will confirm FIPB's December 12th, 2024 email was sent in error, and that its concerning claims do not reflect the official position of the ATF on this issue. Yeah, did this guy write this email? Is he an idiot? Please throw your idiot under the bus and admit he was wrong, and we won't have to do any more. Rather, it's our understanding that pending resolution of existing litigation, the ATF is awaiting guidance and is not taking any definitive positions or issue classifications. Let me know if this understanding is not correct. I request you write me back an answer by the close of business on Wednesday, January 8th. As you no doubt will understand, the ATF's December 12th email is deeply concerning to GOA's members, and we eagerly await your confirmation that the email did not accurately state FIPB's position. Okay, that was from Mr. Eric Pratt, Senior VP of GOA. Dude, he basically called him on it and said, look, why are my people getting this email? There is a court injunction stating you cannot do this. It's wrong. Stop. Please tell me that your employee is an idiot and you're going to fix him. Fix him. Go fix him. So he didn't get a response. So he went to the next step. Yeah, he whipped it out and showed them how long it was. And apparently they were rather impressed. But anyway, this is sent to the Assistant Director of the Office of Program Services, ATF. Again, this is January 9th. That's why we support these people, by the way. That's why I support GOA. He strokes them out an email on the 6th and says, fix it. I want to hear about you by the 8th. Nope. Okay, fine. On the 9th, I'm going to keep going. You won't be ignored. Eric Pratt will not be ignored. He will keep going. And so this one sends it into, Megan Bennett, the Assistant Director. My name is Eric Pratt. I'm the Senior VP of GOA and GOF. We're a nonprofit, etc., etc. As you know, the ATF issued a final rule in 2023, factoring criteria for stabilizing braces. That was that criteria. That was that stupid form I showed you. This rule was slated to affect millions of commonly owned firearms, claiming them to be unregistered SBRs and possessed in violation of the NFA. Yet the rule offered no clear guidance as to when the ATF would consider a brace pistol to be an SBR. Instead, the rule merely referenced the stabilizing brace's surface area and then a 6-factor test that the ATF would consider behind closed doors to make that individual determination. Yeah, me and my buddies are going to go in this other room and we're going to make a determination as to whether or not you were speeding. And if you were, well, we'll say you were. And you have no recourse. Rule of lenity, anyone? Yep, instead the rule merely referenced surface area. Even so, the rule emphasized that only certain weapons equipped with stabilizing braces are short-barreled rifles and regulated. Emphasis added that not every weapon with a stabilizing brace would be an SBR. This was their law that not everyone would. And again, we can come back to here where he says anyone would. Any type of stabilizing brace would be an SBR. He's now contradicting his own rule that was thrown out by the court. Yeah, these are the experts, folks. Yeah, I agree. Experts in what? I totally agree with you 100%. Yeah. Folks, it just keeps going. On October 27th, 2023, the Southern District of Texas enjoined the rule as GOA members and their family members, basically said other district courts have then similarly enjoined and vacated the rule. Reed O'Connor in the 5th District. So what's going on? Now, this is where it gets a little snarky, and this is where we get fun. One would think that the ATF, a federal law enforcement agency, would abide by the district court's injunction and not enforce a rule, not to mention similar injunctions, entered by other federal courts. Unfortunately, one would be wrong. Yes, we would think that a federal law enforcement agency would abide by the federal law. On December 12th, the member received a response. Again, we've talked about that. Specifically, our member reported having recently purchased a CZ Scorpion mini pistol, considering installing a brace. However, having encountered conflicting information, they asked for a clarification. In response, they submitted, again, requires a pistol with any stabilizing brace or stock to be a short-barreled rifle. The email contains no qualification of that broad statement. In fact, the ATF has no idea what sort of brace this GOA member planned to install. In other words, the Firearm Industry Policy Bureau advised the GOA member that if a pistol is equipped with a brace, then it's an SBR categorical matter, irrespective of multiple court's orders, that the ATF not enforce this reasoning, and despite the fact that the rules factorial test and the ATF's assurance that only certain weapons. Yeah. Folks, does it get any better? They continued, despite acknowledging an injunction by the Northern District of Texas against the rule. They then posted that irrespective of the injunction against the enforcement, they remain responsible for the enforcement. So forget about that damn court injunction. We're still responsible for enforcing that law, but it wasn't a law, it was a rule. In other words, it would seem that the FIPB now considers all brace pistols to be SBRs, an alarming change of position that was not announced publicly or in any representation in any court, but rather private communication to one GOA member. Of course, this new position goes much further than even the highly contested final rule, which opined that nearly every, but not every, pistol with a stabilizing brace would be an FBR. And again, we have Mock v. Garland, Lexus number there. That's where you can look at. Under the final rule, the ATF estimated 99% of pistols with braces would be reclassified. Yeah. Folks, they're funny. Even in addition, more expansive than the rule itself, the new position likely violates the Southern District of Texas's court order, Judge O'Connor, that the ATF's expansion of the NFA liability not extend to members of the GOA. They were members of a protected class because they were the ones suing and got the injunction against its enforcement. Ignoring the district court's order in our case, the email adopted a cutesy theory that even though the ATF has been enjoined from enforcing the rule, it may still enforce its interpretation, which coincidentally just so happens to be identical to, if not worse than, the interpretation in the rule. So they're saying, yeah, we can't enforce the rule that got slammed, but we're still going to enforce a version of it that we haven't even told you about. Not only is this spurious theory too cute by half, but likely violates the orders of numerous courts who have expressed that the ATF may not enforce legal theories advanced in the rule. For the ATF to claim and enforce those same theories under the statute but not under the rule is a distinction without a difference, and one that demonstrates FIPB's contempt for the federal courts and the rule of law. Let that sink in for a second. How many times do we hear, well, no one is above the law? Who thinks they are? Who is playing above the law games? I get a hint for you. You got 3-letter agencies, and there's a lot of them doing it. And this is a very, very screaming case of it. Even worse than the FIPB's purported blanket ban on pistols with braces during litigation over the rule, they previously asserted without explanation that the specific firearm at issue here, a CZ Scorpion Mini, with a stabilizing brace attached, was an SBR, but had that conclusion rejected by the Court of Appeals in the 8th Circuit. The ATF judged the pictured weapons to be short-barreled rifles, but the slideshows are devoid of any explanation as to how they applied that rule. They say it is, but they're not going to tell you why or how. They go through, it allows the ATF to arrive at whatever conclusion it wants without explaining the standard on which the decision is held, rule of lenity. The final rule makes it nigh impossible for a regular citizen to determine what constitutes a braced pistol and whether or not a specific braced pistol requires NFA registration. And you will look here as they go through, they're putting all the footnotes and the documents. In other words, the ATF's theory specifically applied to the CZ Scorpion pistol at issue here was rejected as applied to a firearm with a PDW stabilizing brace. And yet, FIPB's email says that the very same firearm with any brace is a short-barreled rifle. The audacity of that claim, which directly contradicts and conflicts with the decisions of two federal courts, cannot be understated. What's more, as the GOA explained to the court in its brace pistol case, numerous prior ATF classification letters have determined that a stabilizing brace, when added generally to any pistol, does not. So, numerous prior ATF letters say that adding this brace does not turn the firearm into an SBR. So, we'll say whatever we want in whatever letter we want. Yeah. It goes through, again, Mock v. Garland, previous brace weapons declaring them no longer valid. The decision was enjoined and then vacated. That was the court decision I showed you, where it was totally vacated. And again, here's all the footnotes to all the legal. I'll post all these documents up over in our locals chat if you want to read them individually. But this means the ATF's prior braced weapons classifications are back in effect, never having been lawfully rescinded. It includes the ATF's repeated determination that certain braces can be placed on any pistol without running afoul of the NFA. And again, one of these classification letters involved a brace on a CZ Scorpion, the very firearm about which our member required. FIPB's email to our member does not purport to rescind that prior classification letter. So we said it was legal, but now it's not. We haven't told you, but you're illegal. We're not aware that the ATF has promulgated any subsequent rulemaking where it is now possible for a regular citizen to determine what constitutes a braced pistol versus a short-barreled rifle. Nor are we aware of any new ATF classification letter pertaining to braces vis-a-vis the CZ Scorpion. Folks, if a law is so arbitrary and capricious that John Q. Citizen cannot read it and make sense of it, the rule of lenity applies and the law is that cannot be used against them. The FIPB is doing precisely what it's enjoined from doing, making ad hoc determinations in secret based on vague and unpublished criteria that no ordinary person could hope to understand. Of course, a designation by an unnamed official using unspecified criteria that is put in a desk drawer and taken out for use at a criminal trial and immune from any evaluation by the judiciary is the sort of tactic usually associated with totalitarian regimes. Ooh, go Eric, go Eric. Yes. A final point bears emphasis. It's difficult to imagine the Firearm Industry Program Bureau's novel interpretation of the NFA, an unprecedented attempt to circumvent the orders of several federal district courts, surviving the imminent turnover in the presidential administration and forthcoming confirmation of a new ATF director. Basically, you might get away with this now, but after next week, you probably won't. To the contrary, lawless actions like this stand out like a sore thumb for those like GOA who seek to stamp out government weaponization and corruption wherever it exists. The GOA previously submitting concerns via email to Acting Chief Matthew Scher and Chief William Ryan Monday the 6th, outlining our concerns with FIPB's interpretation. We requested an answer by close of business yesterday, Wednesday, January 8th. No response was received, and thus it appears that both Chief Ryan and Acting Chief Scher stand behind this unlawful position. On December 12th, an email to our member. Thus, we are elevating our concerns for you. Accordingly, we demand your immediate clarification that the FIPB email sent to our member does not, in fact, represent the official position, but was rather issued in error. I like issued in error. That's like he's giving her a little bit of wiggle room. It was a mistake. It was He didn't deliberately break a bunch of rules. It was an oopsie. He just didn't know. He wasn't trained. He meant what he didn't understand. Yeah. If we misunderstand something, we can get a federal felony. If they misunderstand something, they get a promotion. To the contrary, we demand your strong assurances that your understanding is the mere fact that a pistol is a brace equipped with a stabilizing brace does not, let's see here, render it to be a short-barreled rifle. Finally, we demand your guarantee that the ATF intends to comply with the district court orders enjoining enforcement of the rule. This compliance includes refraining from enforcement of the rule's flawed and repudiated theories repackaged in an injunction sidestepping statutory theory or any other theory which purports to comply with the injunctions, but nonetheless exposes our GOA members to criminal liability. Rather, it's understanding the pending resolution of the existing litigation, the ATF is, or should be, awaiting further guidance and not taking any actions, definitive positions, or issuing classifications with respect to this. Please let us know if this understanding is not correct. Please send your response to us in writing within 3 business days of the date of this email or by the close of business on January 14th, 2025. We remind you, the FIPB email to our member was signed by FIPB, a branch under your direct Office of Enforcement Programs and Services. Thus, if we do not receive your response within 3 business days, we will safely assume that the flawed positions articulated in the December 12th email are properly attributed to you, and in that case, we will proceed accordingly. We suggest you consider this letter carefully and look forward to your prompt reply. Sincerely, Eric Pratt. Yeah. Folks, is there any wonder why I support these people? Is there any wonder why I buy the coffee that will support them? Why? Because let's face it, this is insane. They come out with a crazy rule. It gets litigated all through court. And I mean, decisions upon decisions upon decisions. It finally comes out. A judge vacates the ruling, Judge O'Connor in Texas, vacates the ruling, said it is too vague to apply, cites the fact that it was too vague, it's arbitrary and capricious. And they just keep doing it. Now, I'm a gun guy. Now, I don't work full-time at the ATF. I don't work full-time at a federal regulatory agency. I can quote this stuff off the top of my head. Why can we have somebody who is in Washington, I'm assuming, I don't know where this dumbass is out of, put out that email when you know that these court cases have all gone on? All of this stuff has been fought and fought and fought. Because honestly, I hate to say this, I believe in my heart of hearts that they believe they're above the law. They believe the law doesn't apply to them. And that is horrifically scary. They believe that they're somehow better than or different than. And we don't do that. That's not what this country's about. If they want to have a rule, they want to have a law, fine. Put it out there. Let it get debated. That's how things work. They can't write rules behind closed doors. Put them out. Get enjoined by a court and say, yeah, we're going to do it anyway. This is absolute horrific overreach. And I think this is the cherry on top of ATF. Like Mel says, we get 2 more days. I agree. Personally, I'm all up for AK Jesus to be the new ATF director, although it would be kind of cool. Then we could tell Brandon he's a Fed. But that being said, these people work for us. At the end of the day, in the big scope of things, if they're supposed to be regulating alcohol, firearms, tobacco, and explosives, personally, I can say abolish the ATF, and I don't think I'd get a lot of pushback. But okay, if they have to exist, they should work for the people who pay their damn salaries. They should be a resource, a compliance resource. But no, they're too busy behind closed doors cooking up their next little scheme, their next little, what if we do it this way? It's like Eric said, and again, I support GOA 100%. I support FPC 100%. I support SAF 100%. This is stupid. And it was so stupid and so crazy that the NRA came out and suggested, and I'll just say suggested, that the GOA was lying about it. Yes, that's right. The NRA came out and said, this couldn't have really happened. The GOA was making this up. They said the email was possibly fake. Really? Now, there's plenty of gun organizations out there. NAGR, National Association for Gun Rights. In South Carolina, we have PGR, Palmetto Gun Rights. We have NRA. We have FPC. All these different groups. This article by the NRA, and I'm pulling it right off their website, is friendly fire. Dude, this is fratricide. This is Blue Falcon territory all over the place. Because as the folks at GOA went out to start doing battle, and you've seen the battle, and those emails, all the time it took to cite all those citations and do all that stuff, yeah, we have the NRA come out, and they needed to get into the middle of it. Guess whose side the NRA boys took? Yeah, sadly but true. The NRA boys kind of came out on the wrong side of this game, I think. Let's see here, blow this up. I'll try to make this as legible as I can. I'll pull myself off screen here in a second if you need me to, Mary. Yeah. Okay. On Friday, Gun Owners of America published an email, reportedly received by one of its members in response to a question about whether adding a brace to a CZ Scorpion. Email appears to claim that notwithstanding the nationwide injunction against the ATF's rule, the factoring criteria, ATF now considers all brace pistols to be subject to the NRA. Reportedly received by one of its members? Do you not believe us? Is there no trust among brothers? As we reported at the time, the ATF in January 2023 published this rule, blah, 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 worth of settled understanding about pistols with attached braces, which in many cases could be made or sold without triggering the NFA. The new rule, again, for purposes of the definition, again, they go through here. The factors, however, were almost entirely subjective, didn't give owners of pistols any ascertainable means of determining whether their own system or their own setup was indeed included. A wrong guess, moreover, would be very consequential as they impose felony possession. Yeah. All of this is technically correct, but it's reportedly received by one of their members. Really? Huh? Yeah. Yet an email exchange that occurred between the owner of the CZ Scorpion and ATF in December is now coming to light, suggesting that the ATF intends, even without the rule, to treat all brace pistols as SBRs. When asked if adding a brace to a CZ Scorpion, they stated that federal law requires a pistol with a brace to be registered as an SBR. That statement, if indeed it reflects the ATF's understanding and enforcement policy, would constitute the agency's most aggressive posture on this rule, surpassing the already broad and punitive approach in the 2023 rule. The statement, again, acknowledged that the enforcement of the rule was enjoined and asserted, while the appeal is pending, we're complying with the court order. Yet their idea of compliance is to insert even a broader authority. Yeah, we know we're enjoined from enforcing that, so we're going to overstep even more because we can. Yeah. They come down to the end here, and again, you've heard the story thus far. This is where it gets really interesting. It's important to note, however, the email purportedly received from the FIPB is unsigned. It's not on agency letterhead, and it has not been published in the Federal Register or on the website. Moreover, it deviates from the published rule the agency defends in court. It seems strange, to say the least, that the ATF would go through the resource-intensive process of publishing a rule. The email, by contrast, appears to assert a much broader rule. Let's see here. It's not an agency letterhead. It's unsigned. Well, unless you have a computer, like a signature saved in your computer for your email, you probably have unsigned going out a lot. Yep. Number one. Purportedly received. Yeah. Well, the NRA is a purported firearms Pro 2A organization. Yeah. However, I haven't seen it on their letterhead. This article is unsigned. Maybe it's not theirs. The NRA, there's little subtle aspersions to the GOA member and to the GOA people themselves. Yeah. It's possible, for example, that the email is a product of a single ATF employee who's trying to discourage a particular individual from adding a brace to the pistol and doesn't reflect individual agency policy. Yeah, very possible. Or he doesn't know what policy is. Nevertheless, whoever may have been involved in creating the email, the person or person claims to have answered on behalf of the NFPB. As this article is being published, it's really interesting, they're trying to verify the authenticity of the email and determine whether it accurately states, we'll report on further information as it becomes available. Folks, I don't like same team fights, okay? If the NRA wants to be on the team, fine. You back GOA's play. Eric was taking the lead on this. You could have written the exact same article and said, we've seen this letter and it is very troubling. And we urge you to get on board with what GOA is doing. But instead, this agency isn't on letterhead and it's reportedly received. And, if it's real. Really? Maybe, GOA is like not washing the ATF's cock. I mean, come on. They need to, and again, SAF, FPC, NAGR, them my naggers, GOA, all these groups, there's different groups. I support a bunch of different groups. I've got cards from a gaggle of them. But I'll say this, they need to avoid this friendly fire bullshit. And to me, NRA needs to come out and say, it turned out that this was totally valid, and we're sorry. Because NRA, you owe GOA and Eric and that gentleman who sent the email into GOA a big apology, and we're waiting for it. It was bad enough with all the NRA mismanagement and misspending. It was bad enough with all that. I mean, let's face it, if the NRA was doing their job, because they've been the old dog and they've been around the longest, if they were doing their job, we wouldn't have had 5 other gun organizations popping up all over the place going to battle. But you know what? The NRA has been sitting in a boardroom with one hand in their pants and the other one up their ass, and GOA has been taking the lead. SAF, FPC, they're all taking the lead. And the NRA is sitting here publishing articles and urging us to renew our membership, which I did not. Yeah. And I'm a proud GOA member. I'll say that right now. Folks, if you've got any questions about this, and I know this was long, it was contorted, it was wild, and I am sorry about that. The bottom line is I wanted to get this out there because to me, like I said, even if you don't have brace pistols, if this doesn't show you the insanity of what the, you know, GOA is, or the insanity of what the ATF is. And it does not show you who is truly fighting for our side, GOA, FPC. You can go to the GOA gunowners.org website. You can go to the FPC website, either one of them, and you can look at cases and court decisions, both at state and federal level. You can look at what they're doing. And what is the NRA doing? They're sitting here casting aspersions on the people who are doing the work. Yeah. 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 Kind of reminds me of, our NRA, Institute for Legislative Action. We write some very strongly worded articles. Yeah. Eric Schmidt calls the ATF and sends them an email saying, yeah, you got 3 days to apply. We're going to take more action. By the way, the epilogue of this, the ATF has since totally walked back their email to that young gentleman with his CZ Scorpion Plus. Rock on, bro. I hope you get a cool-ass brace. I hope you have years of fun with your firearm. And hats off to Eric and the folks over at GOA for doing the battle to keep our Second Amendment rights in place. Because you know what? There are people who talk, and there are people who walk the walk. Eric has proven that. FPC also. SAF also. Yeah, again, much the same as certain coffee brands really walk the walk, and we know who they are. Peace out. Hope you have a wonderful evening. Thank you for coming by. If you have any questions, I'm going to be publishing a bunch of this stuff to locals over the next couple of days. You can look through all the documents yourself. Otherwise, be smart, be safe. Good night.